Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. This is Saturday, February 25th, 2023. We are in the studios here of WAUK Radio in downtown Waukesha. It is The Shaw at 540 AM, 101 FM. I'm here with my terrific producer, as always, every Saturday morning. His name is Calvin, and together we are taking your phone calls at 844-967-2789. That number, once again, 844-967-2789. Delighted to have you with us also for our weekend review, our analysis, and our discussion of the most important stories in law, in government, and the aspiration for justice in America. Again, enjoying your contributions to our program every Saturday morning, including this morning, a very special morning on Morning Cannolis, a very special edition, the first of three in a series. This morning, next Saturday, and the following Saturday as well, we're focusing, abandoning a bit our usual format, to focus in particular upon the United States Supreme Court, as promised in previous weeks, talking about the significant issues coming out of the highest court in our land. We're going to spend some time this morning talking again about some structure, some history, some process, some procedure of the Supreme Court, just raw civics for you this morning. And then it turns out that this past week was a big week in the news of the United States Supreme Court. Decisions issued by the Supreme Court, decisions made about cases they're going to be hearing, and yes, perhaps most importantly, some very interesting oral arguments of just this past week on what? On the internet, and on the ways in which the internet affects our lives, could affect our lives in the future, depending upon some major decisions to be issued by this United States Supreme Court, probably in May or June, just a few short months down the road. As always, our ambitious but achievable syllabus is here as a part of our presentation, hopefully also informative and inspiring. We always ask, as we do again this morning about the United States Supreme Court, why is it important? What happened? Why is what happened important? And then what do we do about it? What are we supposed to do as citizens of our nation, as residents of this world, in response to the things going on all around us? Thank you once again for joining Calvin and me. We're actually this morning also consuming cannolis, as we sometimes do if you happen to be in downtown Waukesha, 9 to 11, when we are broadcasting. From time to time, we do have cannolis. Stop in, and Calvin and I will share those with you. This morning, once again, a lot of news to take attention to, a lot of focus on the United States Supreme Court. We know that in other areas of the law this past week, it was also a big week. We know, for example, that Harvey Weinstein was sentenced to 16 additional years for his Los Angeles sex crimes. You know, that former film producer was convicted back in December of raping and sexually assaulting a woman in 2013. We know that Alec Baldwin pled guilty to involuntary manslaughter, some reduced charges based upon his holding a gun on the set of the film Rust when it was discharged, killing the movie's cinematographer. That happened this last week as well. R. Kelly, the singer, was sentenced to 20 years for child sex crimes himself, serving most of that sentence in federal prison at the same time as a 30-year term for racketeering and sex trafficking. R. Kelly likely not to see daylight for the rest of his life. And again, the issue, the story, the news item that much of America is focusing on is Alex Murdaugh, the continuing trial of him for the double murder of his wife and son, on the stand this past week, admitting that he lied many times to investigators, to clients, and to loved ones, but insisted that he was telling the truth about his innocence in the double murder trial. All those things going on this past week in the areas of law and justice and government in America. We're going to spend, however, most of our focus today on the United States Supreme Court. Again, today, February 25th, next Saturday, March 4th, and the following Saturday, March 11th. Continuing with that focus. Why? Because we know as well that we are almost halfway through the present term of this United States Supreme Court. That's right. We're here in late February, almost March. The Supreme Court term lasts, as you well know, from October through the late September of the following year in the middle of the 2022-2023 term. So appropriate as we reach that halfway mark to take some inventory, to talk about the Supreme Court, anticipating once again that probably in about 4 months from now, May, June, probably at the very latest, July, we're going to have some major decisions by the Supreme Court. We have spoken about many of those cases in the past, and we'll revisit those as those decisions, those all-important rulings that also affect our life and livelihood. As those are issued, we will focus on those every single Saturday, May, June, and July as those come up. It turns out, as I said, that this past week was also a big week for news of the United States Supreme Court, issuing some important decisions, 3 decisions just this past week, issued by some interesting consortiums of Supreme Court justice. We're going to talk about one of those among the 3, involving a defendant who is on death row right now, and the importance of that case for the rule of law and access of all of our citizens, regardless of whether they are incarcerated or not, to the rule of law mechanisms. We're going to talk, as a preliminary matter, however, a little bit about court history, to do some basic civics once again this morning, some constitutional trappings, talking about Article 3 of the United States Constitution, what it says, what it doesn't say, some history then that followed on the implementation of that Article 3 in our United States Constitution in 1789, and the very first Congress addressing what? Addressing courts, federal courts in America. We'll talk about that. And then, as promised, in our second hour, after talking about some of these major decisions, some of these very interesting oral arguments of this past week that have to do with everything from Facebook to Twitter to Google, all sorts of things online providers of platforms, responsibilities that they may or may not have for the postings made by their clients and their users. Then in our second hour, as promised, we're going to spend some time talking about 2 major cases that do define who we are in 21st century America. And I've chosen this week, based upon some of your comments and your invitations, to talk, yes, that's right, about firearms. 2 major cases. One of them way back in 2008, another one way not too long ago in 2022, June of just last year. A case called Hiller, another case called Bruin, that are affecting not only who we are as Americans, but the access that we have to firearms, both in our homes and significantly beyond our homes in the public. What did the Supreme Court tell us about 13, 14 years ago? What is the Supreme Court telling us in the past year about the extent to which the Second Amendment is to be defined broadly, perhaps narrowly, by those who criticize those Supreme Court decisions? What does that mean today, and how is it implicated as we go forward in determining what the future of gun laws in America are all about? And, of course, ultimately talking about what safety and security for all of us as we go forward. So a big agenda, huge agenda, ambitious as always, achievable, informative, and inspiring as well. So let's begin with our discussion this morning of the United States Supreme Court. Let's talk about the court as an institution. As I promised this morning, some basic civics, some basic history as well. As you know well, the United States Constitution, established by our founding fathers in 1789, ratified by a majority of the states following that. Article 3 of the Constitution, the third one. Of course, the first one being all about the legislature. Our founding fathers anticipated that our Congress, the House of Representatives, and the United States Senate would be the most powerful, most important portions of our tripartite government, the voice of the people heard by our elected representatives. Question whether that remains true in 2023 and going forward. The second article about the executive branch, thought to be the second most powerful branch when the Constitution was put together. Question once again whether that is true. Has it eclipsed the judiciary? Has it eclipsed the legislature? And the third branch, once again, in Article 3, again, a very significant question as we think about these major decisions that are impacting our lives beyond executive action, beyond legislative action. What is the Supreme Court doing these days under the Supreme Court mandates set forth in the United States Constitution? Under Article 3, the judicial branch is created. A Supreme Court of the United States is described, and such lower courts, the Constitution says, as may be created by the Congress. I'm going to talk about that in just a moment. The article empowers the courts to handle certain kinds of cases, controversies, a real fundamental concept, sometimes called standing, the ability to bring cases into the federal courts, as well as other enumerated areas with great specificity, and also identifies and defines what treason is. Very interesting situation, very interesting description there. Significantly, although the Constitution does say a lot about our third branch of government, it also provides an awful lot of latitude for the things that still have to be filled in by that first Congress. And to this day, the prerogatives of the Supreme Court, the organization of the judicial branch as a whole, still being defined to this day by the legislature and, yes, by the court itself, as it defines what its role is. And we're going to talk about that in just a moment. The establishment of a federal judiciary, among the most important things by our first Congress, the new government constituted right after the majority of the states ratified that Constitution. The very first bill introduced in the United States Senate was one called the Judiciary Act of 1789. And the act divided our country, our small country geographically at that time, our still developing country, into 13 judicial districts. Those districts were in turn organized into 3 circuits. Today we've got 13 altogether, depending upon how you count them. But at that time, 3 circuits: the Eastern Circuit, the Middle Circuit, and the Southern Circuit. The Supreme Court, of course, the highest judicial tribunal at that time, and still to this day, some 240 years later, was sitting in the nation's capital, initially composed of a Chief Justice and 5 associate justices, 6 justices altogether at the start of our nation's history. For the first 101 years of the Supreme Court life, and with a bit of an exception in the early 1800s, those justices, those 6, were also required by legislation to so-called ride the circuit, and that meant that they traveled around the country holding circuit court twice a year in every single judicial district. The Supreme Court first assembled on February 1st of 1790 in something called the Exchange Building in New York City. And it was at that time, that was the nation's capital, of course. The Chief Justice, his name was John Jay, the very first justice. And he was forced to postpone that initial meeting by a day until everybody could make it there on February 2nd into New York. Right after the break, we're going to talk more about what happened in the wake of the Supreme Court's Constitution way back in February 2nd of 1790 and the history that brings us current up to this day in America. Stay with us. We are back. Thank you for staying with us in our civics exposition this morning, talking about all things United States Supreme Court, a little bit of history, a little bit of background, a little bit of process and structure to get us into our discussion about some major things that happened in Washington, D.C. on Capitol Hill at the building of the United States Supreme Court just this past week. We're going to talk about those decisions that were rendered. We're going to talk about some decisions made about cases to be heard. And then also some very important oral arguments that give us some sense, actually don't give us some sense, about how the Supreme Court may be deciding on some all-important issues related to the Internet, the World Wide Web, and our access to social media, the ways in which social media platforms may or may not be responsible for the things that are posted by the users of those. Right before the break, I was talking a little bit about history and the fact that our Supreme Court constituted itself for the first time, New York City, February 1, actually February 2nd, 1790. John Jay, also one of the authors of the Federalist Papers, as you all know well. John Jay, the first Supreme Court justice. The earliest sessions of the Supreme Court mostly devoted to organizational things. How do we get along? How do we structure this? What do we do? Again, because the Constitution itself did not say a lot about the practical trappings of the Supreme Court. The first cases that reached the Supreme Court didn't happen until its actual second year. Didn't have any business until the second year. Can you imagine that today? The justices handed down their first opinion on August 3rd of 1791. It was a case called West versus Barnes, sort of lost to the history of America and jurisprudence, but nonetheless, In the first decades of its existence, the Supreme Court did render some very significant opinions, some rulings among those 6 justices, and established some precedents that are lasting to this day that affect the way in which the Supreme Court works. The Supreme Court justices also complained, however, a lot about their stature. They're being viewed as this third sort of tertiary branch of government, seeing that the legislature, again, would be the major factor, the major mover and shaker in terms of government in America. The executive branch also being very significant, the presidency and his, at that time, continuing to this day, his executive agents and offices. The judiciary identified itself as being sort of a poor stepchild. And they also complained about having to ride circuit during these times of primitive travel conditions. Chief Justice John Jay resigned from the court, probably in part because of those reasons. In 1795, he became the governor of New York right after that, and not an unusual thing to happen at that time. And despite the entreaties, the pleadings of a president named John Adams, he couldn't be persuaded to come back in 1800 when the position opened up again. And so shortly before being succeeded in the White House by Thomas Jefferson, John Adams appointed a fellow named John Marshall. John Marshall, a lion in Supreme Court jurisprudence and history, as our 4th Chief Justice. John Marshall, again, perhaps one of the most important Chief Justices of our entire history. The appointment of him, his time on the bench, probably one of the most important. Marshall took a very vigorous and a very strong leadership role in those formative years still of the court, central to the development of it as this prominent role, this decision maker in American government. His immediate predecessors had served only briefly, as my history here, my thumbnail history indicates, but Marshall remained on the court for 34 years and 5 months, almost 34 and a half years. And several of his colleagues at that time, the other 5, remained on the bench for more than 20 years. And of course, as we have spoken in the past, one of the major decisions coming out of the Supreme Court in those first years, a case called Marbury versus Madison. Everyone who's taken civics, whether it's in junior high school, college, as adults, we all know about Marbury versus Madison, this notion that it is the express and the province of the judiciary to decide what the law is. A declaration made by the Chief Justice, John Marshall, fairly boldly at the time, in the early part of the 19th century, saying that we're the ones who tell you what the law is. A case called Marbury versus Madison had to do with a dispute between John Adams and Thomas Jefferson about an appointment made as one administration was leading into another. So a lot of history there as our Supreme Court began its time in office. A couple of very important things that are in the Constitution and things not in the Constitution that also have relevance to this day. The members of the Supreme Court are appointed, of course, subject to the approval of the Senate. By whom? By the president. Again, nominated by the president, confirmed by the United States Senate. Some of them have been confirmed. More than a few have not been confirmed in our recent history. In past history, that happens all the time. And to ensure what was regarded as an independent judiciary, something that's set forth in the original documents of our nation, including the Federalist Papers, the Founding Fathers decided to protect the justices from partisan pressure by providing that they would serve their entire term under what's called good behavior, B-E-H-A-V-I-O-U-R. What does that have been interpreted to mean? It's been interpreted to mean that justices, once they are confirmed, and yes, this applies to all federal judges around the country as well, district court judges, appellate court judges, they stay in their office for life, lifetime tenure. And to further ensure their independence, the Constitution also provided by its terms that their salaries could not be diminished while they're in office. In other words, can't diminish their salary if you don't like the decisions that are coming forth. Not a non-controversial position to take. Again, today, all of our federal judges, including justices of the Supreme Court, remain in office until one of 3 things happen. They either depart, they resign, and yes, we've got 4 former Supreme Court justices who are still out there, who are still with us. Here's your first pop question of the day. Who are those 4? Perhaps we'll talk about that down the road. And second, that those justices' salaries, again, cannot be diminished during the course of their term. The other two ways that they can depart the office, of course, they can not die, and we've had that happen fairly recently in our recent American history. Ruth Bader Ginsburg, of course, Antonin Scalia, who we're going to talk a lot about in our second term, and also could be impeached. Justices can also be impeached. All of those kinds of things in the Constitution. What's not in the Constitution? How many justices are there? We're going to talk about that issue right after this next break. Thank you for staying with us on our Saturday morning discussion today of the United States Supreme Court, a little bit of civics to begin your Saturday morning, and right before the break talking about the lifetime tenure of all federal judges under the United States Constitution. That includes Supreme Court justices. Once the president nominates them, the Senate confirms them, they are there for life and depart only under three instances: their death, their resignation. Again, that's occurred 4 times in our recent history. And there are 4 justices out there, former Supreme Court justices, still very active in many ways. And also, justices can be impeached. There was one justice way back in the early portion of the 19th century named Chase, who was impeached. He was not removed by the Senate, but you can be impeached as well. And so that's about the lifetime tenure that otherwise attends Supreme Court justices under the Constitution. That can only be changed by a constitutional amendment that would get rid of that good behavior language, which again has been interpreted to ensure that justices remain in place throughout their lives. However, the number of justices, that can be changed legislatively. And believe it or not, the number of justices on the Supreme Court has changed 6 times until it's settled at its present number of 9, which is what we're used to now. That happened way back in 1869, went up and down, fluctuated all over the map based upon some political machinations, not surprisingly, between major parties fighting about who should be in charge of, who should be the decision makers on the Supreme Court. Since 1790, there have been only 17 chief justices and 104 associate justices, most of them serving for an average of about 16 years. So again, that's a little bit about the tenure of justices. Once again, the reason why this number of justices relevant today, we're seeing, as we have in this administration, prior administrations, proposals, focuses, advocacy for the appointment of more justices, perhaps to balance out the perception that the present Supreme Court is not truly representative of the United States population. And that has happened, of course, in our history as well, perhaps very notably in history books, FDR, when he was very unhappy with some decisions being rendered by the then existing Supreme Court justices on his New Deal proposals, striking down a lot of the things that he wanted to do to get the country going again, economically, socially, politically, culturally, all those kinds of things. Supreme Court saying no to him repeatedly, and he threatened to do what's called the court packing plan. Remember that from history? Adding maybe 3, 4, 5, 6, 7 other justices, again, to balance out the Supreme Court and vote in his favor, presumably, when those justices are nominated and perhaps confirmed by the Senate. That, of course, never happened, because what happened in the end, historically, as we know, is that the Supreme Court began to play ball, if you will, with the president and said, okay, we're going to approve more and more of your decisions about the New Deal, and the decision to go ahead with a court packing plan at that time never advanced. But this president, the current president, also commissioned early on a group to take a look at things like lifetime tenure. That, again, cannot be changed absent Supreme Court, absent constitutional change to that third article in the Supreme Court Constitution. And second, also looked at this issue about numbers of justices and came back and said, you know, there are reasons for doing it, there are reasons for not doing it. And, of course, our history, once again, we fluctuated everywhere from 5 associate justices up to now 8 associate justices. It has gone all over the map. That could be accomplished legislatively, perhaps not as heavy a lift as doing a constitutional amendment, but under present circumstances with a divided Congress, perhaps also very difficult, likely that we will remain at 9 justices, including the Chief Justice, for the foreseeable future. And so finally, with that by way of civics teaching and some civics review this morning, Saturday morning, let's get to one of the first stories of this past week related to what our Supreme Court is in fact doing on a daily basis. One of my favorite headlines from this past week reads this way: when do creepy Facebook messages cross a constitutional line? When do creepy Facebook messages cross a constitutional line? The Supreme Court announced this past week that in April, a couple of months from now, just a few weeks from now actually, it will decide, it will hear arguments on a question that it once ducked, it once evaded, and that is whether intent counts in criminal cases based on online threats. Now, the last time that the Supreme Court considered what the First Amendment has to say about threats generally, including things said in public forums, believe it or not, the Chief Justice, this fellow named John Roberts, during the course of an oral argument, was reciting some lyrics from, that's right, the rapper Eminem. And this is what the Chief Justice said from the bench of the United States Supreme Court way back in 2014, an argument at that time. Quoting once again Eminem, he said, "Dada make a nice bed for mommy at the bottom of the lake? There goes mama splashing in the water, no more fighting with dad." At the time, of course, that grabbed an awful lot of headlines because John Roberts isn't necessarily the kind of person you would anticipate quoting Eminem, especially as the Chief Justice, from the bench, from the court of the Supreme Court itself. The decision about 6 months after that was not nearly as notable. The Chief Justice wrote for the majority. He was overturning at that time, this again way back in 2014, the conviction of an estranged husband, listen to this, who had harassed his wife with ugly Facebook posts in the form of rap lyrics. That's why the Chief Justice opted to talk about lyrics of Eminem right from the bench. The Chief Justice, however, that time ducked, basically evaded the First Amendment question. That is, what is the capacity? What does the First Amendment say about the capacity of individuals to post things on Facebook? Freedom of speech, freedom of expression, and delivered instead an opinion that was so cryptic, so perhaps indecipherable, that the other justices complained about. Believe it or not, Justice Clarence Thomas, also usually on the conservative side of the bench, wrote that the Chief Justice's, quote, failure to decide throws everyone from appellate judges to everyday Facebook users into a state of uncertainty. Well, it may well be that uncertainty now, as a result of this decision made by the Supreme Court just this past week to hear another Facebook message case, also incorporating, conveying threats, we may get some more clarity on this. That may happen sometime soon, including oral arguments coming up in April. How does this come about? How do we begin to address whether creepy Facebook messages cross a constitutional line? Well, it will hear arguments again in April in a case involving a fellow named Billy Counterman, Counterman. He has this fixation with a Colorado singer-songwriter identified in court papers, the official documents, only as CW. Those are the initials. Counterman is fixated with this singer-songwriter, sends her many messages on social media platforms, including Facebook. And I'm going to read to you some of them just to give you some sense of what this case is all about. All of those accounts, she's blocking him. Some of these are, in fact, disturbing, but nonetheless, we have seen a lot of this in our social media. It brings to the fore the importance of this decision. This Counterman fellow says this. He says, "Was that you in the white Jeep posting this on Facebook?" He says, "I'm currently unsupervised. I know it freaks me out too, but the possibilities are endless." And then goes on to say, "You're not being good for human relations. Die. Don't need to." And finally, he says, "Staying in cyber life is going to kill you. Come out for coffee. You have my number." Again, more than creepy, disturbing, very upsetting postings on Facebook. Again, stalking this singer-songwriter with whom he is obsessed. So what happens? Counterman, for doing that, is prosecuted again in Colorado, where he lives, where he is doing this. Obviously, he's sending these Facebook messages out across the world. Under a Colorado law, what does a Colorado law say? It says it makes a crime to send repeated communications, here's the important language, that would cause a reasonable person to have serious emotional distress and did in fact cause that harm. Once again, this law prohibits people from sending these communications, social media, including Facebook, that cause a reasonable person to have serious emotional distress and causing that harm significantly. And this is the reason why this case is now coming to the Supreme Court, that Colorado law does not require proof, does not require a showing by the prosecutor that the defendant, the person who posts these creepy, these inappropriate, disturbing statements on Facebook and other social media platforms, doesn't require proof that that person intended to cause the distress. And so what happens under that standard, Counterman is convicted and sentenced to 4.5 years in prison, again, in Colorado State Court. And when the Chief Justice quoted Eminem back in 2014, he suggested those lyrics that, again, he recited from the bench might be seen as threats made in a domestic dispute. And he posed that question to the government lawyer. He said, could that be prosecuted? And the government lawyer came back and said, this is a critical part of context. It wasn't as if he, that is Eminem, stated that in a private Facebook page or some other mechanism that was not seen public. He was on stage and so made this distinction. The Colorado Solicitor General, in the case now before the Supreme Court, made a similar argument in the Counterman case. He urged the justice not to hear the case at all. Said this, he said, a context-driven objective inquiry, not looking at intent, right? Not looking at the purpose, the meaning, the intention of the player, the actor, the defendant, one that looks only to the words in question, how they were conveyed, the response they elicited. That's enough. That's enough to satisfy the mandates of the First Amendment. And the speaker's subjective intent, this focus that usually attends criminal cases, does not matter. That was the position of the Colorado Solicitor General, arguing in support of the conviction and the sentence imposed upon Counterman. Now, significantly, again, a little bit of civics here this morning. First Amendment does not protect all speech, as we well know. There are many exceptions articulated by the courts, including the Supreme Court, for things like libel, incitement, obscenity, fighting words, and one for true threats, which is what is at issue at Counterman's case. The Supreme Court has not been especially clear about what counts as a true threat. In the 2014 argument, Justice Kennedy, who's, yes, one of those four who's now retired, resigned from the Supreme Court, still out there, said, I'm not sure that the court did either the law or the English language much of a good service when it said true threat. It could mean so many different things. The case itself included conflicting contextual clues, and the defendant in that case, a fellow named Alonis, had posted disturbing tirades laced with violent imagery after his wife had left him. Many of those things very, very graphic, very, very inappropriate, fantasized about killing an FBI agent, said hell hath no fury like a crazy man in a kindergarten case. Again, in that case, ducking the First Amendment question, the Chief Justice interpreted the law at that time to require the prosecution to do more than prove that reasonable people would view these statements as threats, but the state of mind mattered too, the Chief Justice wrote, but he failed to identify exactly where that legal line should be drawn. And in a 2017, he had a third case, again, following all this, in a third case in 2017, Justice Sotomayor said, we've got to clarify this. We've got to tell the courts out there, we've got to tell, frankly, the world whether or not you can be held criminally responsible depending upon your intent in imposing and posting these kinds of inappropriate, offensive, and arguably graphic and violent kinds of things on social media. The 2000 case involved an individual named Robert Perez. He's serving more than 15 years in a Florida prison for what may have been, according to Justice Sotomayor, who is, again, looking for more direction, more than a drunken joke. Here's the story behind that one. Perez and some of his friends had been drinking a mixture of vodka and grapefruit juice that they apparently called a Molly cocktail. They went to a liquor store, probably never a good idea, already inebriated, for more supplies. And in an apparent misunderstanding, a store clerk at that time understood Perez to be discussing a Molotov cocktail. The group laughed, and they continued with this conversation. The inebriated Perez apparently continued this banter, telling another employee that he had only one Molotov cocktail and I could blow the entire place up. Under Florida law, the intent, again, which was not there, did not matter. Even as the prosecutor in that case argued for a 15-year sentence, she acknowledged that Perez may have just been a harmless drunk guy at the beach. Those words. But Sotomayor necessarily said in that 2000 case, we need to give the world, we need to give the country, we need to give prosecutors and defense attorneys better direction on whether or not one has to actually intend to convey a threat in doing this. And so that's the reason why this case is now before the Supreme Court. Oral argument on the intent necessary to support a criminal conviction for postings on social media. When we come back, we're going to take the first of our callers this morning and then move on to some other important issues, other news in the Supreme Court jurisprudence of just this past week. Stay with us. We are back for this special 2-hour edition, our broadcast on the United States Supreme Court this Saturday morning, talking about some major decisions made by the Supreme Court about taking cases. Right before the break, this case involving whether or not you have to show intent to support a criminal conviction for people posting what appear to be, objectively, threats on the internet, including Facebook. Case going to be decided during this term, argued in the month of April. And then later in this 2-hour broadcast this morning, we're going to be talking about some other very important cases having to do with the liability of platform providers like Twitter and Facebook and Google and others for ensuring that there is access to their platforms, including by people who post things that are incendiary and that may prompt violent behaviors. Very important issue, somewhat different from this other issue about threats, but nonetheless related. The impact of the technological improvements and advancements of our time and the ways in which liability, civil liability, criminal liability can be imposed in America in this time of our lives. Dick, you've been on the phone for a while waiting for a comment, question from you. Thank you so much for joining us once again this morning, Dick.
Well, it's just a comment on the court itself in that it can be summed up this way with me. The respect for it or confidence in it going forward. I've got a little cartoon I cut out of New Yorker magazine posted in the garage, and it's got a picture of the Supreme Court, and behind Clarence Thomas it says, happy wife, happy life, and behind Kavanaugh it says, I like beer. Now, when you have two people like this on the court, neither of which should be there in my opinion, no wonder the court's overall opinion, where is it now, down in the 20s?
It has certainly declined dramatically. Yes.
Yeah, when I was a kid, I can remember when you actually looked to that as the supreme thing, like you're going to get the fairest and most just answer from that body. And now it, to me, is almost looked at as a joke. And
Dick, your comments, again, spot on, right, in terms of certainly the drop in reputation. I remember that time, too. A lot of my history during my life, decisions that not everybody agrees with, but decisions always moving forward, right? Major civil rights decisions in the 1960s, supporting the Voting Rights Act, which we're going to talk about next week in our broadcast. Other things related to housing, environment, even politics, even elections, those kinds of things, always moving in the right direction. And I share your concern, not only about the reputation, but also about the rendition of decisions. Later in this hour, we're going to spend a little bit of time, probably not enough, talking about these other major cases decided by the Supreme Court in our lifetime involving firearms and the possibility that today, in a change in what has been 200 years of jurisprudence, for the first time in our lifetimes, the Second Amendment interpreted to establish not only a right to possess and use firearms in the home, but now, as of last June, to use firearms, to carry firearms in public. Dramatic changes that do affect our day-to-day lives, and also, not incidentally, the reputation of a high court that for many years, had a much better reputation than it does today. Appreciate that comment, Dick. keep that cartoon up in your garage. This present Supreme Court, as we know it is constituted, did in fact also this week issue 3 decisions. 3 decisions came out, kind of flew under the radar in America. Not a lot of attention being given to these two or three. I'm going to spend some time talking about just one of them. One of the cases called Bartenwerfer, Bartenwerfer versus Buckley, had to do with a bankruptcy code and a question about whether a debtor who is liable for a partner's fraud can discharge her debt in bankruptcy. Again, a bankruptcy case, very important to bankruptcy practitioners and, frankly, the economics and commercial status of our nation. That case decided this past week. Also, a case called Helix Energy Solutions Group versus Hewitt. The question is whether under the Federal Labor Standards Act, the Hewitt plaintiff, the petitioner, not an executive exempt from the FLSA's overtime pay guarantee, the daily rate workers of whatever income level, do they qualify as paid on a salary basis only if the conditions set forth in the Code of Federal Regulations are met? Again, a fairly specific, fairly in-the-weeds kind of implication of the Fair Labor Standards Act. Also a significant case in that area for employment law decided this past week. The one I want to spend most of the time talking about in the next few moments is a case called Cruz versus Arizona. Cruz versus Arizona. Again, the issue in Cruz versus Arizona, like the 2 other cases, sounds hugely technical, and it does have to do with some interplay between precedent and the present status of the law, but it affects whether defendants, criminal defendants in America, have any remedies when their rights are violated. So it stands for much larger propositions. That's why I want to highlight it somewhat. The case is also about the basic principles of the rule of law. So what is this case all about? Cruz versus Arizona decided this past week a very interesting combination of justices. The Supreme Court, the United States Supreme Court, just this past Wednesday, a few days ago, ruled in favor of an inmate. His name is John Montenegro Cruz. He is in Arizona. He was sentenced to death by a jury that was not told during the course of its deliberation that a life sentence would ensure that he remained in prison for the rest of his days. They were not told by that. And what is the significance of this? Well, the vote was 5-4 by our Supreme Court. And listen to this. The Chief Justice, typically on the conservative side of the bench, voted along with, yes, Justice Brett Kavanaugh, joining the court's so-called 3 liberals. They are, of course, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, to create a 5-member majority to form that majority and rule in favor of the defendant, Mr. Cruz. The ruling will basically allow this inmate, Mr. Cruz, who remains in prison, to press his argument upon remand, going back into the Arizona court, that he is entitled to a new sentencing before a jury that is told, the jurors told, that they would be informed that any life sentence that they would impose would not include the possibility of parole. In other words, they would be told that if they do in fact impose a life sentence, Mr. Cruz would remain in prison for the rest of his life. Significantly, Cruz was convicted of the 2003 murder of a fellow named Patrick Hardesty. He was a Tucson police officer. And at his trial in 2005, his lawyers tried to tell the jury that he would not be eligible for parole if he gets a life sentence, obviously arguing for a life sentence as opposed to the death penalty. And a Supreme Court decision had ruled that capital defendants like him have a constitutional right to do so. Significantly, the trial judge, first time around in this Cruz case, refused to tell the jury that. And he ruled that a 1994 decision did not apply to Arizona's sentencing scheme and recommended, as a result, the jury recommended a death sentence. Right after the break, I'm going to tell you what happened in the wake of that and why this case is so important, not just for Mr. Cruz, certainly, but for all of us concerned about jurisprudence in America. Stay with us for that discussion as well. morning. It is Saturday, February 25th, 2023. For those of us continuing from our first hour, those of us who are joining us for the first time in this hour, we're spending our morning today talking all about the United States Supreme Court and some major decisions made by the court in connection with decisions rendered, rulings, opinions issued, also some decisions made about cases it's going to hear. And then we're going to spend a lot of time in this hour talking about some very important oral arguments of Tuesday and Wednesday of this past week that quite literally affect the future of the internet and the possibility of the imposition of civil liability for internet providers when users of those platforms post things, messages, information items, misinformation items that may result in horrific consequences. We'll talk about that in just a moment. Thank you once again for joining me and my wonderful producer, Calvin. We're here at the studios of WAUK Radio in Waukesha, always taking your phone calls at 844-967-2789 as we continue our focus on what happened, why is it important, and what to do about it this week, next week, and the week after that, focusing on rulings, decisions, actions of the United States Supreme Court. In our final moments of the first hour, we were talking about this all-important case decided by the Supreme Court on February 22nd, just this past week, involving an inmate who is facing the death penalty imposed upon him by a jury in Arizona that was not told that if they, in fact, voted for a life sentence, he would not be eligible for parole. Now, why is that significant? Well, we know that in the wake of the imposition of this death penalty upon John Montenegro Cruz for what is admittedly the horrific murder of a Tucson police officer way back in 2003, nobody is disputing the fact that he needs to face justice and should either be in prison for the rest of his life or face the death penalty. The question is due process, appropriate application of the laws and the rule of law in Arizona and in our federal courts, even for those who have committed these kinds of heinous crimes. Everyone entitled to justice, as 5 members of our Supreme Court this past week determined. Those 5 members, once again, the Chief Justice, John Roberts, Brett Kavanaugh, joining with the other 3, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, defined that the Arizona court, the Arizona judge, that had failed to advise the jury of this option, that is, to impose a life sentence that would not carry with it the eligibility parole, that the failure to do that resulted in a violation of Mr. Cruz's rights. And so we know that following the recommendation of this death sentence by a jury, what happened? 3 jurors issued a statement saying that they had made what's called a gut-wrenching decision, their words, not mine, and that, quote, there was not one person on the jury who did not cry. They said that they would have voted for life had they known that there was no possibility of parole. A 4th juror later on made a same statement. In other words, convinced that this man, Mr. Cruz, should never, ever see the light of day, but nonetheless probably inclined to impose a life sentence if they knew that he would not see the light of day, would not be subject to parole, not advised of that. So they presumed that if they imposed a life sentence, he might be released someday. And that's what they did not want to accomplish, not advised that that would not happen, and instead voted for the death penalty. Justice Sonia Sotomayor, writing for the majority, said Arizona got it wrong. The judge needed to instruct the jury about this aspect of their decision-making process. And she said that Cruz's case was a rare one in which the Supreme Court should, in fact, second-guess a state court's interpretation of a state law. It's a little bit more complicated than I'm even describing right now. It has to do with the implication of state law and some Supreme Court justice decisions involving a case called Lynch versus Arizona. Supreme Court Justice Sonia Sotomayor went on to say this past week that Lynch overruled binding Arizona precedent. Before Lynch, Arizona courts held that capital defendants were not entitled to inform the jury of their parole ineligibility. Lots of double negatives there. Have to follow along very, very closely. But after Lynch, after this major decision, again, this according to Sonia Sotomayor, writing for the majority, the decision of the Supreme Court, after Lynch, Arizona courts recognized that capital defendants have, here it comes, a due process right to provide the jury with that information when future dangerousness is at issue, it is hard to imagine a clearer break from the past. And again, 5 members of the Supreme Court siding in favor of the defendant, sending this back down for resentencing, in which the jury will be told that, in fact, he would be ineligible for parole if they vote for a life sentence. Significantly, Justice Amy Coney Barrett joins Justices Clarence Thomas, Alito, and Gorsuch in dissenting. The court makes a case, she said, for a case why the Arizona Supreme Court's interpretation of its own precedent is wrong. She says, if I were on the Supreme Court, I might agree, but that call is not within our bailiwick. Says we shouldn't be playing around with this at all, and so they dissent, but not enough votes to overcome the majority decision. Cruz versus Arizona, a major capital case, a major case for rule of law and the imposition of justice in America just this past week by our United States Supreme Court. More of those coming up plainly in May, in June, maybe even in July as well. And so let us turn now, finally, in this second hour of our broadcast, talking all about things Supreme Court related, to talk about 2 major oral arguments conducted by all the justices in Washington, D.C., at the Supreme Court building, a building that was built and opened in 1935. Ever since then, convening at that location. Yes, it's now open once again post-COVID. You can go and you can listen in. You can visually see the justices. You can wait in line and watch as they hear these oral arguments, which they're doing routinely now. Still can't tour the building. That may happen at some point down the road. Significantly also, by way of public service here, I'll also indicate that these oral arguments, that is, these opportunities for the justices to question the parties about their positions. They're not making decisions. They're simply engaging in questions and answers, comments back and forth, as you will hear in just a few moments, about the merits and demerits of the cases before them. Those oral arguments are continuing, many of them already conducted, as we talked about, in the fall of this past year, resuming now, once again, in early 2023, anticipating that decisions like the one in Cruz will be coming forth in the coming months, especially, again, May, June, maybe July. This past week, Tuesday and Wednesday, again, when other focuses of our nation were grabbing the headlines, the Supreme Court entertained oral argument in 2 major cases that quite literally could impact the future viability of what we know as the internet and social media platforms. Let's talk about these 2 cases. They're called Gonzalez versus Google. Yes, that Google. And Twitter, yes, that Twitter, versus Taamneh, Taamneh. Let me tell you about both of them. They're somewhat related, but they come about in slightly different ways. They invoke slightly different statutory codifications. Let's begin with the first one of them. We've spoken about this a little bit in the past. Nohemi Gonzalez. She was a 23-year-old college student from California. She was studying abroad in Paris in November of 2015. You may remember the events of that time. They commanded worldwide attention. She was among the 130 people killed in a coordinated series of terrorist attacks. Recall this, throughout the city of Paris, riveting. 130 people killed in these terrorist attacks. She was a first-generation college student. She was studying there design. She was studying design there in Paris at the California State University location coming out of Long Beach. She was killed while she was out with friends during this Paris attack in 2015. And significantly, the Islamic State, ISIS, ISIL, we sort of know them by both of those monikers, both of those acronyms, later claimed responsibility for these horrific attacks in Paris in 2015. She was the only American that was killed in those attacks. The next year, her father sued Google. On what basis? Sued Google and some other tech companies on what basis? He specifically accused the firms of spreading content on that platform, the Google platform, that radicalized users into becoming terrorists. And as a part of his complaint in this country, said that therefore Google was legally responsible for the harm that was inflicted on the Gonzalez family as a result of Nohemi's death. Her mother, stepfather, brothers eventually joined that lawsuit as well. the claims were in fact heard by the United States Supreme Court after coming up from lower courts just this past Tuesday. And their lawsuit, Google, now the exclusive defendant in these cases, it could have seismic, quite dramatic ramifications on the social media platform. How does this case come about? What is the sort of the legal basis? What are the Supreme Court justices wrestling with just this past Tuesday? The suit takes aim at a federal law. You probably have heard about this because it's somewhat been out there. It's called Section 230 of the Communications Decency Act, passed way back in 1996. Doesn't sound that long ago to me, but actually at the genesis, the beginnings of what we know as social media platforms today. The Section 230 Act, the Communications Decency Act. And what does it say? It shields online platforms like Google, like Facebook, like Instagram, like YouTube from lawsuits over content that is posted by their users or for their decisions that they may decide, those platform providers, to take content down. Let me say that again. Section 230 Communications Decency Act provision prevents the imposition of liability, civil liability, for content posted by their users or the decision to take that content down. The case gives the Supreme Court justices this opportunity to determine whether or not that shield should be applied, gutted in its entirety, potentially opening up companies to liability. Right after this break, we'll talk more about the implications of Gonzalez versus Google, and we'll talk specifically about how the Supreme Court justices articulated their initial views about this when we come back. Stay with us for that. Welcome back to our continuing discussion this morning of all things Supreme Court. Right before the break, talking about this case called Gonzalez versus Google. The justices hearing this past week this case challenging Section 230 of the Communications Decency Act, decades old, that protects places and platforms like Google, Facebook, and others from lawsuits over what their users, including you and me, might post online. Again, this case coming out of the horrific death of Naomi Gonzalez in the horrific Paris attacks of November 2015, credited to and accepted responsibility for by ISIS. And so the question here, whether or not indeed Section 230 of the Communications Decency Act remains this shield, or should the Supreme Court take a look at that law and find that it should be rolled back in one way or another? Critics of Section 230 say that it lets the tech companies avoid responsibility, plainly, for these kinds of harms that are alleged by the family of Naomi Gonzalez, and further facilitates this kind of activity, potentially to the harm of many people out there. Supporters, of course, counter that without that legal shield, these companies, these tech companies, will take down more content than ever to avoid lawsuits, potentially compromising this notion of freedom of speech and freedom of expression that we have come to understand the social media platforms to be all about. And the Supreme Court, again, wrestling with this issue about the extent to which social media platforms are responsible for what their users post online. An argument of just this past week, fascinating in many, many ways. A sprawling argument lasting almost 3 hours before the United States Supreme Court. The justices seem to view the positions in both directions as too extreme. Either side too extreme, giving them, on the one hand, again, this choice between exposing these search engines, these online platform providers, and Twitter with liability on the one hand, and protecting algorithms and other mechanisms that seem to promote this pro-ISIS or other incendiary content on the other. And so not a happy choice to make. At the same time, interestingly, the Supreme Court justices seem to express doubt about their own competence to find some middle ground which again they often try to do. The Supreme Court Chief Justice himself, Elena Kagan, who we're going to hear from a lot in these cases and future cases, said, these are not like the 9 greatest experts on the internet. And that prompted laughter within the Supreme Court courtroom this past Tuesday. Other justices, as a very practical concerns, Brett Kavanaugh, echoing comments made in some of the briefs, the written documents submitted by the parties in favor and opposition to the proposals of the parties in these cases. He worried out loud that a decision imposing limits on the shield, imposing a limit on this Section 230 of the Communications Decency Act, would, as he said, really crash the digital economy with all sorts of effects on workers and consumers, retirement plans, and what have you. So he's concerned about the impact upon restricting Section 230. Drawing lines in this area, he said, was a job for Congress. There you have it, often repeated by the Supreme Court. We shouldn't be involved in this. The legislature has to act. We are not equipped to account for that, Kavanaugh said. The case comes, of course, as these cutting-edge events happen, not only involving Nohemi Gonzalez, her horrific death, but also other implications of things posted of an incendiary nature, a violent nature, an indoctrinating nation. Justice Kagan said that this was a pre-algorithm statute. She said the statute basically is outdated. It provided scant guidance, she said, in a post-algorithm world. Neil Gorsuch also voicing his views on this during the course of the oral arguments of the past Tuesday. He marveled from the bench at the advances in artificial intelligence. He said artificial intelligence generates poetry. It generates polemics. So as we got all this sort of academic musings on what AI is all about and the implications of this decision. Again, very important. The other justices also weighed in that. Justice Clarence Thomas said that recommendations were vital to make internet platforms more useful. He said this: if you're interested in cooking, you don't want thumbnails on light jazz. Again, talking about the applications of algorithms and the access to various things on the internet. He later added, I see these as suggestions and not really recommendations because they don't really comment on them. Again, a lot of pronouns there. He's talking basically about trying to find different solutions to these problems. Kagan went on to say, I can imagine a world where you're right, that none of this stuff gets protection. And every other industry has to internalize the costs of its conduct. She went on to say, why is it that the tech industry gets a pass? A little bit unclear. On the other hand, Kagan went on to say, we're a court. We really don't know about these things. Again, indicating that these 9 justices may not be, as she said, the greatest experts on the internet. Sam Alito said he was lost. He said, I'm lost on this. I don't know where you're drawing the line, he told one of the advocates in front of him. That's the problem. The provision, again, Section 230 says this: no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by any other information content provider. That provision, of course, helped to promote the rise, the increase, the development of places like Facebook, social networks like Twitter, others, ensuring that these sites did not and do not assume legal liability for every post. The issue here, again, is whether or not that fundamental principle set forth in Section 230, whether that continues or not. A ruling against Google would either force the sites to take down some content, presumably that was remotely problematic, maybe allow no content at all. But again, other arguments on the other side about this, about the impact of these kinds of things posted on social media. Supreme Court wrestling with that this past week. When we come back, we're going to talk about the other case, also argued, much related, in this same area on Wednesday, a case called Twitter versus Taamneh. Stay tuned for that discussion as well. Continuing this morning our discussion of the United States Supreme Court and these fascinating and potentially very, very important decisions of the United States Supreme Court when it comes to online platforms, groups like Google and Twitter, Facebook, and others that provide opportunities for, yes, communication and discussion under the First Amendment, but also provide platforms for groups like ISIS or ISIL to present incendiary, indoctrinating misinformation that may ultimately result in horrific results. We talked about the implications of that with respect to the case called Gonzalez versus Google. Nohemi Gonzalez, this 23-year-old California student, horrifically murdered in the Paris melee back in November of 2015. And the oral argument before the Supreme Court this past Tuesday of her family that under Section 230 of the Communications Decency Act, they in fact should be permitted to go ahead with their civil lawsuit against Google for permitting the posting of these incendiary, indoctrinating messages that prompted ISIL or its actors effectively to kill their daughter. Fascinating, horrific question, but fascinating question at the same time, and potentially affecting the future of the internet. On Wednesday, the Supreme Court heard another case. Sounds an awful lot like the Gonzalez case, but slightly different in terms of its predicates. This case, Twitter versus Taamneh, Taamneh. How does this one come about? Well, this case concerns an individual named Nauris Alassaf, Alassaf. He, like Nohemi Gonzalez, was also killed in a terrorist attack, but in a different place. He was killed at a terrorist attack in a nightclub in Istanbul in 2017. And ISIS, the Islamic State, once again claimed responsibility for that attack that resulted in Mr. Alassaf's death. His family, like the Gonzalez family, in the other case, sued Twitter and some other tech companies as well. And in that lawsuit, that civil complaint, they said that the Twitter executives had effectively allowed ISIS to use their platform to recruit and train terrorists. That's the basis for this lawsuit. And the Supreme Court again heard oral arguments this past Wednesday on this question of whether internet platforms may be sued for, here we go, aiding and abetting international terrorism by failing to remove videos supporting the Islamic State. Now, the case, again, just like the other one, concerns a federal law. This one a little bit different, but again, much related. This federal law allows suits for knowingly providing substantial assistance to terrorists. And again, it's linked to the other case on Tuesday. But this one is different because unlike the Section 230 of the Communications Decency Act, which is the Gonzalez predicate, this one is premised upon the Justice Against Sponsors of Terrorism Act. And again, it allows civil lawsuits for parties under many conditions, other circumstances, for knowingly providing substantial assistance to terrorists, plainly that results in damages or injuries. And again, the family of Nauris Alassaf maintaining that's exactly what Twitter did by providing ISIS with this opportunity, this platform to indoctrinate people that resulted in this horrific terrorist attack that resulted in the death of their son, Nauris. The question again before the Supreme Court is whether or not that is a legitimate cause of action under the Justice Against Sponsors of Terrorism Act. Interestingly, fascinating oral argument once again. Lawyer for Twitter stressed that the plaintiffs, again, the family of Mr. Alassaf, had not accused his client of providing substantial assistance, much less knowing substantial assistance for that attack. So he draws this line between substantial assistance directly provided, adding that it was undisputed that Twitter had no intent, again, that word intent that we talked about previously, to aid terrorist activities as a part of their regular operation. The attorney went on to say, what we have here is an alleged failure to do more to ferret out violations of clear and enforced policy against assisting or allowing any postings supporting terrorist organizations. So what did the Supreme Court justices say about all that? Well, Justice Sonia Sotomayor, once again weighing in this, told that attorney that the fact remains that you knew that ISIS was using your platform. Those words from Justice Sotomayor. Brett Kavanaugh once again weighed in on Twitter's position. He said whether there's a legitimate business that provides services on a widely available basis in an arm's length manner, it's not going to be liable under this statute, even if it knows bad people use its service for bad things. In other words, tipping his hand that he will probably support Twitter in this. Kagan went on to say, they, that is the platform providers, provide 100 other clients who are not terrorists with the same kinds of banking services, drawing this analogy between financial institutions. But they provide this known terrorist with these banking services that are very important to its terrorist activities. Can you go after that person under this statute? The attorney, again, for the family said yes. You can go after the customer as long as somebody was a leader or somebody who you know has committed or is about to commit a terrorist act is in fact involved in the lawsuit. Justice Kagan came back and said, well, maybe that banking and social media are not that different. Went on to say, we're used to thinking about banks as providing very important services to terrorists. Maybe we're not so used to, but it seems to be true that various kinds of social media platforms also provide very important services. Amy Coney Barrett suggested the decision in favor of Twitter on this case in the Wednesday's case could effectively resolve both disputes, the Google case and also the Twitter case, and we will see. We will see what happens in these cases now pending in front of the United States Supreme Court, no less the importance of the future of the Internet, whether or not providers of platform services, including providers under the First Amendment, can be held liable, and the impact of that, if indeed they can be held liable, whether it's under the Terrorist Act, the Sponsors of Terrorism Act, or the more omnibus act involving the Communications Decency Act and Section 230. We will wait to see what the Supreme Court says about all of that. Probably a mixed result, again, among the justices. No clarity from the oral arguments of Tuesday and Wednesday of this week. Clarity coming up probably in May or June on these all-important oral arguments. We have got a caller who's calling in. Tom from St. Paul, thanks for staying on the line. Your comment or question this morning on our broadcast.
You have a lot to talk about, but I'm talking about the Colorado case where the jury is going to be re-instructed about applying the death penalty.
Yes.
And I'm wondering if the Supreme Court could take the extremely wise route of abolishing the death penalty altogether, because it is at cross purposes with the Declaration of Independence aims to that we're all equal and to secure life and liberty. So employing the death penalty just totally throws life and liberty out the window. And instead, they could contract with Cuba, the individual states could contract with Cuba to send people to Gitmo in exile. And we could pay Cuba for taking care of the people for the rest of their lives in exile.
Well, lots of good thoughts there, Tom. Lots to unpack there. I'm going to address just the first portion of that because you've, whether it's stumbled upon or identified purposely, a major part of the Supreme Court jurisprudence has to do with the Eighth Amendment that prohibits cruel and unusual punishment. That's what you're really talking about in the Constitution when you say that it should be prohibited. You should know that to this day, there is, of course, a huge dispute out there about whether or not the Eighth Amendment that prohibits cruel and unusual punishment does in fact prohibit or permit the death penalty in America. The Supreme Court, up till this time, has not adopted your particular view, but nonetheless said that it is not a cruel and unusual punishment to impose the death penalty as long as a number of prerequisites, procedures, processes are in place for review and analysis. And that is the state of the law today. That is not to say, Tom, that the Supreme Court could not reverse that position. There have been Supreme Court justices, and presumably we've got at least 3 of them on the Supreme Court right now who would take the very view that you're articulating as well, that the Eighth Amendment does prohibit the death penalty, and that this years-long, decades-long position should be overturned, and that under the Eighth Amendment, the death penalty should be prohibited. That's the kind of thing that, that's why it depends so dramatically upon who is on the Supreme Court. The issue that you've raised about the implications, not only of this Cruz case, but more broadly, about whether or not under our Constitution we should be putting anyone to death, is one that the Supreme Court has wrestled with up to this time, has said you can do it as long as states, and again, here in Wisconsin, we do not have the death penalty. Other places plainly do. Arizona, obviously, Texas, many other states. Whether you do that is a decision of the state legislature, as long as there are sufficient safeguards in place to ensure due process, equal protection, all kinds of things to ensure that we do this most dramatic thing that a government can do in terms of doling out some sense of justice in America. Very important point. Other issues related to other alternatives out there, those are the kinds of things that are a part of the debate, Tom. So very much appreciate your comments and your questions about that. Very important. We'll stay on top of that as more death penalty cases certainly come before the Supreme Court, maybe not in this term, but in future terms as well. Got other callers on the line. Jake, I'm calling also about our program, presumably this morning, your comment or question for us.
Yeah, I'd like to say that I think companies like Facebook and Twitter should no longer be allowed to have it both ways. You know, they want to say there should be no legal liability because they're not publishers, so they're not to be held accountable for whatever kind of incendiary thing that maybe put on their platform that leads to someone's death. But then they want to say they're not utilities. And they spent billions of dollars over the years convincing people around the world that, in fact, these things like Facebook and Twitter and other social media sites are necessary to a quality life. And you have, many Americans who agree with that. Basically anyone under 40, try to tell them no social media for you. And
right.
yeah, they would probably agree that they're utilities at this point and should be regulated as such. For instance, Twitter as a utility should have never been allowed to be sold to an egomaniac like Elon Musk. So at this point, they got to choose. Are they publishers or are they utilities?
Right. And Jake, you should know, again, you should be at the Supreme Court, perhaps. That's exactly what some of the justices were concerned about. What is the nature of this kind of communication platform, and what is their status? Are they simply public avenues for general expression under the First Amendment, or do they provide a service? And depending upon how you define what they do, if they're a utility, can they be regulated, and how should we regulate them? Your point, I think, very well taken. Some self-definition has to happen here. The Supreme Court also this past week plainly sending the message that, gosh, the questions you've raised, Jake, other things out there, kind of beyond their expertise, and scratching their head when Justice Alito says, you know what, I'm kind of lost, and Justice Kagan says we're not especially equipped to do these kinds of things, underscores the difficulty of wrestling with 21st century technology using, again, statutes passed in the 20th century. Great comments by all those comments, Jake. Appreciate your calling in as well. We also have Rico on the line calling in. Rico, we appreciate your comment or question.
Hey, Jim. Thanks for doing the show this morning. Hey,
Absolutely.
it kind of this question I got kind of ties into this whole wheelhouse of the social media. Jim came up earlier this week, and I'd like for you to explain it, maybe just the fundamentals and the boundaries of something that was referred to as the Hatch Act.
Yes. And
how might today's social media platforms and internet play into that? And thanks, Jim, man. I'll take your answer off air.
Sure, Rico. Good comment. I'll be brief here because we're almost going into a break. But to take your comment, Hatch Act has to do with the prohibition on government officials from engaging in politics. Can't advocate for campaigns. Every so often, we've got government officials who do run afoul of that. And the Hatch Act plainly is a public prohibition on that kind of activity. We'll talk more about that and other things when we come back from this break. And we're going to talk more about some of the Supreme Court other decisions in the past right after this brief break. back for our final minutes, our final moments together, talking about all things Supreme Court. Right before the break, Rico had called in with this question about the Hatch Act and the interaction between it and social media providers and the public in general. Hatch Act, as I said, this prohibition, lots and lots of different aspects to it, for the most part, prohibits people in government from crossing over the line from their official capacities to endorsing, promoting, otherwise advancing political candidacies. And so every so often you will see someone who gets a little bit of trouble if, in fact, in a public and an official capacity they are endorsing or somehow approving or somehow encouraging voting for a particular candidate, otherwise advocating for the election of someone. And this is the reason why, Rico and others, for example, you do not see on the campaign trail this year and next year members of the cabinet of the president out there campaigning along with him, advocating for his reelection or the election of anyone out there. Just once again, because government in terms of its integrity and its purpose should not be promoting a particular candidacy. That's for the private sector, if you will, to do. That's for Americans generally to be making decisions on, not using the trappings and the offices of official offices to promote candidacies. Plainly implicated by the public forums that places like Twitter and platforms like Google, others provide, can in fact be promoted and be accomplished privately by individuals. But if you're a public official, generally the recommendation is to stay away from anything like that. Doesn't mean you can't vote. Doesn't mean you can't have your private views, but not just in the public domain, whether it's spoken or also on a public platform like Google, Twitter, and others, Facebook, and so forth. So appreciate the question tremendously, Rico. In our final moments of this broadcast, we're going to begin what I promised at the outset, which is going to continue in the second of our 3 series of discussions about the Supreme Court. I promised before that we'd be talking every single session over the course of these 3 about a couple of cases that have dramatically impacted life and livelihood in America. And we're going to begin in these last moments, going to continue this next Saturday in talking about firearms in America. We've had callers in recent broadcasts who've talked about the onslaught, the crisis, the challenge presented by firearms in America. We know that just in this past year alone, in places like Enoch, Utah, Goshen, California, Monterey Bay, California, Half Moon Bay, California, Los Angeles, Washington, D.C., East Lansing, Tate County, Mississippi, plainly Memphis, and yes, just this past week, Orlando, we continue to suffer as a nation from problems with huge challenges presented by guns in America. What does the Second Amendment say about all that, and what has the Supreme Court said about it as well? Well, we know that from a recent decision, which we're going to get to next time, Supreme Court, just this past June, in a case called Bruin, said that in order to support restrictions and controls and other rules and regulations, those rules and regulations imposed by state legislatures, by local bodies, have to be consistent with the nation's historical tradition of firearms regulation. That's the present standard. We're going to get back to that next broadcast as we talk more about what Bruin means. But today, going to begin to talk about the nature of this problem. A group called the Gun Violence Archive, a legitimate, nonpartisan, apolitical entity, a nonprofit research group that examines and provides information about gun violence in America, has established that by mid-February of this year alone, we've had 80 mass shootings in America, 7 of those involving 4 or more fatalities. What is a mass shooting? Some disagreement about the definition of that, but for the most part, a mass shooting understood to be a situation where 4 or more people are shot. Could be killed, could be injured, 4 or more people are shot. 80 of those mass shootings in America up to this point in our calendar year. Last year, 647 mass shootings in America, 21 of those involving 5 or more fatalities in 2022. Again, we have a challenge in America. We have deaths in America. And the question is, and the question posed to the Supreme Court almost 15 years ago, and again just last year, is what do we do about that? And what does the Second Amendment say and mean when it comes to firearms in America? Let's start this discussion knowing we will anticipate more of this at the start of our next broadcast. What does the Second Amendment say? It says this: a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. That is the Second Amendment to the Constitution. That's all it says. It was proposed by the first Congress in 1789, again shortly after the Judiciary Act of that year, ratified by the states in 1791. And again, by way of introduction, for over 200 years, that language, the Second Amendment, has not been interpreted by the courts, including the United States Supreme Court, to establish a constitutional right in any individual to firearm ownership and use. Let me say that again. For most of our nation's history, that language in the Second Amendment has not been interpreted by the courts, lower courts, the district courts, the federal courts, at the appellate level, at the Supreme Court level, to establish a constitutional right in any one individual to firearm ownership and use. In fact, on 4 occasions in our history, the Supreme Court explicitly rejected that Constitution and application of the Constitution itself. And so that brings us to recent history, including 2008 and then again 2022. And that's the focus of what we're going to begin right now and continue in the second of our 3-part series on the Constitution, plainly addressing firearms in America. Let me tease it by saying this. In 1975, based on reports and findings of widespread gun violence, domestic violence, public gun violence, the District of Columbia, the legislature there, enacted legislation that banned residents from owning handguns and mandating that they be stored disassembled in their homes. And that legislation in 1975, coming out of the District of Columbia, resulted in a case called Heller. Heller versus District of Columbia, decided by a majority of the Supreme Court in 2008, in which Justice Antonin Scalia, writing for the majority, said this: the Second Amendment protects an individual's right to possess a gun unrelated to service in a militia, and to employ that weapon for traditionally lawful purposes, such as self-defense in the home. Next time, and in our future broadcasts, we're going to talk more about that case, Heller. We're going to talk more about Bruin, the Second Amendment, and the importance of all these cases for our lives and our livelihoods in the United States of America, for all of us in our times that we live. Thank you for joining us this day. Join us again next week for that continuing discussion of our United States Supreme Court. Have a good week, everybody.